Greetings, ladies and gentlemen. I'm Mukesh Bhutani, your host for today. I'm joined by my colleagues Ashutosh Dixit, who's an off-counsel to the firm, and Karishma Fatafekar, who's a partner and transfer pricing leader in the firm. Today's presentation is going to cover impact of multilateral instrument, safe harbor, and its interplay with other forms of dispute resolution mechanism. We would like to thank you for joining us for this special BMR Advisors webinar on the impact of these recent changes. As a reminder, for the duration of this webinar, all participant lines will be in the listen-only mode. The total duration of the webinar we anticipate will cover in about 1 hour and 15 minutes, which will include about an hour of presentation followed by 15 minutes of Q&A. During the webinar, all the participants who have questions can send them to the link in the Q&A box below, which will be addressed by us during the Q&A session. We will endeavor to answer as many questions as we can, but just in case we are unable to, we will pick up select questions and send answers to you when we send you the link to the presentation. Now, the topic is very important and timely as well. What we intend doing is covering it in 3 modules. One, the most important change, the multilateral instrument, the massive signing ceremony for which the Indian Finance Minister, Mr. Jaitley, went to Paris on the 7th of June. We will also cover some of the changes in the safe harbor rules. And then finally, we want to cover the interplay between the safe harbor rules and other forms of dispute resolutions in light of India signing the MLI, because the scenario is likely to change from what it is presently. Let me now hand it over to my colleague Ashutosh Dixit, who's a seasoned policy maker and essentially has seen how policy is shaped up for 25 years, including the chief architect of the Direct Access Code, to take us through how the multilateral instrument has evolved and what has led to India's signature. Over to you, Ashutosh.
Thank you, Mukesh. And as Mukesh just mentioned, India was one of the 68 countries or jurisdictions which signed the multilateral convention to implement tax treaty-related measures to prevent base erosion and profit shifting. And going forward, this is quite a mouthful, so we'll be calling this the multilateral instrument, popularly the MLI. And this was at a joint signing ceremony in Paris on the 7th of June, as just mentioned by Mukesh, where India's Finance Minister, Mr. Jaitley, was present at that signing ceremony. What is unique about the MLI is that it is an attempt by all these countries, 68 countries as of now, countries or jurisdictions, to modify their existing bilateral tax treaties through a multilateral convention. And this is a part of the anti-base erosion and profit shifting initiative, for which the group of 20 countries and the OECD came together and worked over a period of 1.5 years. So when the final outcomes of the BEPS initiatives were a series of 15 action plans, and most of these action plans relate to amendments to domestic law and to tax treaties in order to counter base erosion and profit shifting, and therefore, to plug the gaps currently existing in the mismatches in tax rules in different countries, which then allows taxpayers to artificially shift profits to low tax or no tax jurisdictions. So it was realized during the process of formulating these BEPS provisions that in order to implement those provisions where tax treaties themselves, which historically have been bilateral, negotiated between 2 countries, in order to make those changes in those tax treaties, the whole current edifice of bilateral tax treaties and the negotiations, if that process was gone through, this would lead to a very complex mechanism, and there would be no, it would be an exercise which would be extremely time consuming. So therefore, the concept of the MLI, and one of the actions therefore was that the countries would come together to formulate a multilateral instrument in order to implement the BEPS related measures in the actions 1 to 14. And so the work on the MLI was initiated in parallel along with the development of other BEPS actions. And it was the MLI text and an explanatory statement along with that text was adopted in November 2016. And all the countries who have signed on to the MLI are also members of the inclusive framework on BEPS. And this inclusive framework on BEPS is supposed to create a peer review mechanism where these countries will be reviewed by their peers on how they are implementing the BEPS related measures to which all these countries had agreed to. So India, being a member of the G20, has played a prominent role in both the being part of the ad hoc group which drafted this multilateral instrument, and it's also taken the lead among these other countries to sign up on the MLI. When we talk about the multilateral instrument, we need to understand that it's the way it is going to sit along with tax treaties. It's going to be very different from what currently protocols to tax treaties do, where they actually go ahead and amend tax treaties. So what are the nuances of the MLI? Each country is going to be called a contracting jurisdiction. And while at the time of signing of the MLI, all the countries who are at time of signing, they are supposed to give a particular template position, which is called their MLI, provisional MLI position. And what that provisional MLI position does is that each country lists the bilateral tax treaties which it wants to be covered by the modifications which are to be undertaken through the MLI. So, for example, India has listed all its 93 tax agreements. Then there are certain minimum standards which all the countries agreed to, and these minimum standards also cover certain amendments in treaties, and those minimum standards relate to anti-abuse provisions in the treaties, and also with regard to improvement in dispute resolution procedures. So the MLI has articles which covers these minimum standards. It also has provisions where there are best practices which are recommended, which can be optionally opted to by countries. And therefore the MLI itself, when it has been drafted, it has been drafted as a very flexible document. And let me point out what those flexibilities are. So one of the flexibilities is that even when you are opting for a particular article, and just to point out that the MLI has 39 articles, but Articles 3 to Article 17 are the substantive provisions. And in each of these articles, countries have also been given the options of how they want to implement a particular article. And therefore, in the MLI provisions, they can mention their reservations for those particular articles which are not implementing minimum standards. For those articles which are implementing minimum standards, they have certain flexibilities about how they want to operate those particular articles. The ones which are optional, they can opt in, and while opting for those particular articles, they again have certain flexibilities. And there are opt-out provisions for those articles which were not part of the minimum standard. So the modifications which will happen to bilateral tax treaties, as I mentioned, these modifications will be in form of that particular article of the MLI being read along with these tax treaties. And so while those existing provisions in the bilateral tax treaties will still stand, but the MLI article will go ahead and say that these two countries have agreed to modify this particular provision in a particular way. What is the importance of the signing ceremony is that right now countries have basically stood up and said that they want to be part of the multilateral instrument, and they have also given their provisional MLI positions. But the MLI itself will come into force only once at least 5 jurisdictions, they go through their domestic procedures of ratification, and having ratified their MLI positions and their signatures to the MLI domestically through their domestic legislative provisions or executive provisions, they have to then go and deposit their ratification instruments to the OECD Secretariat. The OECD Secretariat will also be the Secretariat for the MLI, and it's only once the 5th such jurisdiction has made this deposit of its ratification instrument that the MLI will, what you say, is enter into force. Subsequently, other jurisdictions, as and when they sign in, the MLI will enter into force for those jurisdictions. There are also provisions in the articles regarding what is the time period once the entry into force of the MLI has happened. When will the entry into effect essentially take place? So this will, I would say, is that this will come before us sometime in 2018 and perhaps 2019 as countries go ahead and sign and ratify their signatures which they have already made. Before I hand over to Mukesh for actually now speaking about the MLI provisions and India's options and India's reservations which it has given on the multilateral instrument, just wanted to point out to you that the 3 articles on which each country who is a signatory to the MLI has to definitely give a position are 2 on anti-abuse provisions. So one is Article 6, which basically is importing a statement into preambles of all tax treaties that tax treaty is not meant for tax evasion or tax avoidance or to promote instances of treaty shopping or instances of double non-taxation. So there's a specific language which has been mentioned in Article 6, and countries as a minimum standard have chosen that this particular language should get added to their preambles if they are not currently there. The second is Article 7, which essentially talks about an anti-abuse provision to be imported into all tax treaties. That is also a minimum standard. And the third is Article 16, which basically talks about the availability of a mutual agreement procedure to parties, to taxpayers from both jurisdictions who are parties to that particular multilateral instrument, and a certain minimum period by which, a 3-year period by which they are allowed to raise issues where they have tax disputes with the contracting state. So essentially with these 3 minimum standards, there are other optional ones also. So I'll hand over now to Mukesh to talk us through India's options which it has given and positions it has taken on the MLI.
Sure. Thanks, Ashutosh, for summarizing the minimum standards. So if you look at slide number 6, which is the box slide, we have put out essentially 9 relevant articles of the MLI that have implications on India. Ashutosh summarized the 3 relevant articles, Article 6, 7 and 16, which are minimum standards, and we'll try and debate at a later stage what is the impact of India applying the principal purpose test and with a simplified limitation of benefits insofar as the recent concluded treaties with Singapore, Cyprus and Mauritius is concerned. We will also look at the implications of Article 16 as a minimum standards, which is a 3-year threshold for the purposes of determination of dispute under a mutual agreement procedure, because this has direct relevance with other forms of dispute resolution. But very briefly, let me touch on 2-3 other important articles which are of relevance. Article 10 Article 12 and Article 13 deals with changes that are likely to be triggered off insofar as the permanent establishment and the attribution rules are concerned. Suffice for me to mention that all the provisions India has affirmed in the MLI are consistent with the views India expressed in the 2009 OECD Model Convention, which will make the source-based taxation insofar as permanent establishments are concerned much more stricter. Just wanted to move ahead and talk about two other important articles. Article 3 that deals with transparent entities. Interestingly, India has held a view that the treaty benefit will not be available to transparent entities. This is again consistent with the view expressed in the past by India, but inconsistent with the views expressed by the judiciary insofar as decisions of some of the tribunals in Mumbai is concerned with respect to UK law firms and decisions of the Authority of Advanced Ruling. Article 4 is a very interesting article. It talks about situations in which the competent authorities will eventually determine the tiebreaker rules vis-a-vis determining a residential status of a company. India has accepted that. However, this is also subject to India's bilateral treaty partner accepting the same, and if it for any reason it does not accept, then Article 4 will not trigger off. Having said that, the underlying risk is that India has now place of effective management rules where it has a final say on determination of residential status in the event or tiebreaker rules could not be applied in the context of treaty. So these two are just merely illustrations of how conflicts in treaties are likely to arise on articles which are not part of the minimum standards. So we will still need to wait and see what kind of reservations are expressed by India's treaty partners, and if those reservations are expressed, that will not form a part of the covered tax agreement, and it cannot be read along with the treaty, no matter what view India has exercised. Now, let me move on to a very important Article 17 of the MLI, which talks about dispute resolution. Very briefly, I just wanted to mention that the current dispute resolution framework in India is fraught with risks for foreign investors insofar as the timing of determination of such disputes is concerned. So the article provides for mandatory binding arbitration. 25 nations so far have accepted the mandatory binding arbitration. India has held on to its position that because of sovereignty reasons, it cannot accept mandatory bilateral arbitration. Instead, it will improve its mutual agreement procedure and subject themselves to the peer review process, but the peer review process will not entail participation of taxpayers. Now, these are very, very important statements of intents that are coming out. Let me quickly pause over here and ask a question to Karishma, that in light of Article 17 on the MLI, how does she see how the MLI will help resolve disputes in the future?
Yeah, thanks, Mukesh. I think the basic comment here is that, India has always held out to the position where it refused access to transfer pricing disputes under MAP or bilateral APA to date in absence of Article 9.2 in a tax treaty, and which you can see in a lot of tax treaties that India has with European states. Now, India has chosen to apply this provision, Article 17 in the MLI, except where similar provisions are already present. So this would effectively mean that this provision will be added to the treaties with MLI signatories that do not contain such a provision. Treaties with existing similar provisions have been specifically excluded by the reservation, and therefore this will now open up access to bilateral APAs and transfer pricing disputes in MAP to several treaties. So I think this is a very positive, move from an India standpoint, where the dispute resolution will, of course, platform will increase to consider a bilateral APA or MAP with countries where earlier we did not have Article 9.2. Having said that, just one point of concern is on the timing, right, which is what India has not adopted to, which is faster resolution under MAP. And if that can also be looked at, in the final provisions that India considers, then that put together with this will also expedite dispute resolution in a big manner.
Thank you, Karishma. We have some overall observations on the MLI before we move on to the second segment on safe harbor. One, premature at this point in time to conclude what India's final position would be. So I think one has to wait and watch. And Ashutosh earlier talked about as to how does he see things moving forward from here on to the time when every country has expressed their provisional position. It is also possible that some of the positions will not be expressed as a part of the MLI, but there will be bilateral treaty negotiation. And to us, it seems at this point in time, Germany is a classic example. India is in the midst of negotiation of treaty. Well, it has been for the last 4 years with Germany. Germany has not covered India in its preliminary positioning, which means that it's possible that India and Germany will sit and discuss it bilaterally within the framework of the MLI. Largely, our view is that India is holding on to its position that it held out. Now that India is a party to the MLI, it seems that there would be only bilateral renegotiations of treaty which will be important. And at this point in time, given the position India has expressed in its provisional outcome, assuming all of the countries accept it, India's treaty network will remain impermeable to any form of tax planning. I talked about the simplified limitation of benefits along with the principal purpose test. What will that do to the renegotiated treaty with Singapore, Mauritius and Cyprus? There were already questions that were open whether the Indian GAR will apply over and above the limitation of benefits test, simplified limitation of benefits test and the principal purpose test. But now there is another variable that has come in. It is expected that India will, loosen its position and be consistent with the treaty that it has signed with Singapore, Mauritius, Cyprus, particularly given the fact that these are recently signed treaties and India would have been aware at that point in time as to what position it is taking insofar as the MLI is concerned. There is no stronger assurance that India has given for bilateral dispute resolution. So I have a slight disagreement with Karishma that the bilateral dispute resolution will improve. I would say that it will get fastened up and hastened up, but we still need to see whether it will improve. So the only thing India has subjected themselves to, which is a part of the minimum standard, is the peer review process. It needs to be seen purely from a regulatory and a constitutional standpoint whether India will introduce a separate law to incorporate the MLI provisions as what is popularly called as a dualist nation approach, or will it execute the MLI within the delegated powers under the Income Tax Act, and the Income Tax Act being statutory power under the Constitution of India. My hunch is that investors will find themselves more comforted if India has a separate law. However, that needs to be seen whether India comes out with a separate law. The fact that before India went on to sign the MLI, it was approved by the cabinet suggests to me that India would possibly have a separate law. But it's uncertain at this point in time. We will need to see India's position on grandfathering of existing investments vis-a-vis a treaty network with Mauritius, Singapore, and Cyprus. So that's really a summary of what we wanted to discuss on MLI. Let me hand it over to Karishma to take us through the recent changes in the safe harbor rules.
Yeah, thanks, Mukesh. So moving on to the safe harbors, which has again been a recent introduction in the last few weeks. Again, overall, it's a very positive move by the government because this has been anticipated for the last 2 years in terms of revising the safe harbor markups. But just to go a little bit back in terms of the history of the safe harbor rules, these were really introduced in September 2013 on the basis of the recommendation of the Rangachari Committee. And the objective of this was really to reduce litigation, especially in highly contentious sectors like the IT and IT-enabled sectors, which is the BPO and the KPO sector, where we were witnessing taxpayers, tax authorities making high adjustments in terms of imputing high markups, which were upwards of 25 and 30%. And that is why there was a need to really get this safe harbor rule. But unfortunately, the way it was perceived, it really didn't work in that manner because based on the overall global scenario and, bilateral positions, the markups were on the higher side. The markups that we had in the earlier regime were as high as 20, 22%, 25, 29 and 30% in some cases. And these really were not viewed as an acceptable position by a lot of multinational companies because if they were applied unilaterally, there would definitely be issues on the other end for the tax authority to accept such high markups. But yes, now with the revised safe harbor rules, these are amended with effect from June 2017 and will apply to assessment year 17-18 and to assessment years, which would effectively mean your financial year which you've just closed, which is financial year 16-17, and the return for which you will file in November, you can opt for this new safe harbor and you will have these provisions applicable for the next 2 assessment years. Interestingly, for this year, which is the ongoing years, they have kept an option which is open to the taxpayers to either opt for the old safe harbor rules or the new safe harbor rules. And, one would of course wonder as to why would somebody go with the higher markup. But this has got to do more with the threshold limits because, if you see the safe harbor rules, the way they have now been amended, there is a threshold of up to INR 1 billion. And there is a second threshold of between 1 billion and 2 billion. So the markups that are now applicable is 17% if you're a company up to INR 1 billion, which is up to 100 crores, and up to between 100 and 200 crores, 18% markup. This in the old safe harbor rules, the thresholds were not 1 billion but 5 billion and was 20% and 22%. So the option really that is given, in the current year is for the larger companies, the ones which are above 5 billion, and they want to still consider a safe harbor this year, they can opt for it. The second category, which is again a very interesting amendment that they have made in the way they have classified a KPO. So what they have done is they have linked the markup of the KPO services to the employee cost ratio. And this is in line with the thought process that has been plying the minds of the tax authorities when they have been carrying out regular audits, that if the employee cost of a particular company versus the comparable is not comparable, then you really can't take that company as a comparable in the situation. So they have looked at 3 scenarios. If your employee cost is less than 40%, your markup is 18%. Which is basically essentially trying to say that, okay, then you are in line with being an ITES. Because if you see the ITES markup is about 18%. If you are a company with a employee cost between 40 and 60%, then they have increased the markup to 21%. And if your employee cost to total cost ratio is above 60%, which means you're paying really high employee cost, then the assumption is that there is high-skilled manpower and a lot of, investment is made in employing highly talented, qualified resources, which is why the employee cost is high, and therefore it would entail a higher markup. What is also important is the definition of employee cost. And the safe harbor rules have gone ahead and exhaustively defined that employee cost would include not only a pure salary cost, but all other perquisites, welfare, etc. And apart from that, it is also considered a scenario where if the work is outsourced and there is some subcontracting expense, then it is assumed that if you can identify that what is the employee cost in the subcontracting expense, you add that. But if you cannot calculate that, then you assume 80% of the subcontracting cost to be part of the employee cost. This is very interesting because, we have high court decisions which have really said that if you subcontract the work, then effectively that business model is not comparable to a company which is actually rendering the services on their own. But here what the tax authority is trying to do is to say that even if you're subcontracting, then 80% of that cost will be assumed as your own cost and you can still consider it to be the same bucket. The other important change in the safe harbor rules is in case of loans advance. Now, in this case, earlier we just had two buckets, where we had, if the quantum of the loan was less than 50 crores, then the rate would be, the SBI base rate plus a spread of 150 basis points. And if it was above 50 crores, then it would be a spread of 300 basis points. Important point here is there was no distinction between an INR based and a foreign currency loan. So the earlier safe harbor rates were very high because they were assuming the base rate to be the SBI rate, which would be in the range of about 8%, 7 to 8%. Now, the safe harbor rules have provided a distinction between an Indian denominated currency loan and a foreign currency loan, which is good because your cost of borrowing for an INR denominated loan will definitely be higher, or your opportunity cost of funds, versus a foreign currency loan where generally the tribunals and the global precedent is to use a LIBOR as the base. Another important change that they've made in the loans advanced safe harbor is linking the spread to the credit rating of the AE. And interestingly, they also say that the credit rating would be the credit rating given by CRISIL and no other company. So I think, here also there are a lot of riders, but yes, this is now a good platform at least for you to consider different scenarios. If you're not able to even have a credit rating, then they've given a scenario that, okay, you can consider a 425 basis points on the SBI or LIBOR. The other important amendment is the guarantee commission, which has again been a very contentious issue. And we have seen when this issue was started, guarantee commissions upwards of 10-12% were levied by the tax authorities, which kind of got plateaued down to 3%. And in the APS scenario, you have guarantee commission rates which are agreed between 0.25 to 0.75%. This is again very way off as compared to what was there in the earlier safe harbors, which was 1.75% and 2%, based again on the limit of the guarantee. Now they have removed the limit and they've just said, it would be 1%. So I think this again is the most simplified version that they have kind of created in the safe harbor rules, and this will be very beneficial. Manufacture and export of core and non-core auto components, there has been no change. The markups remain the same. And for contract R&D services, right, which is again was an issue, with us, what is contract R&D, and assuming that there is higher amount of skills involved, what should be the markup? Here again, they have reduced the markup from 30 and 29% to 24%. So I think this again is more in line or closer to some of the APA outcomes, that we were observing on contract R&D and R&D for pharma companies. And the last important amendment is on, and which is quite a surprise for all of us because, India was never wanting to adopt this, low value adding intra-group services. And we suddenly saw that in the safe harbor, which initially, people were very happy and elated about India accepting the positions. But when you got down to reading the fine print, we realized that there were too many riders. And effectively, my personal view on this is that 90% of the companies, even though they're paying up to 10 crores of intra-group services, would get excluded because of these many riders. But I would pause here and, I would request my colleague, Mr. Ashutosh Dikshit, to share his perspective on the policy side, because what is really the intent and, why India has really considered only payments and not receipts. So over to you, Mr. Dikshit.
Yes, Karishma. So if we look at what happened in the BEPS action plans and what was actually proposed in terms of intergroup services or low value intergroup services, was that in order to come to a simplified kind of a conclusion, because it was very difficult to really monetize and quantify these services, was that as long as there was a rational cost allocation key for intergroup services between an MNE, then a 5% markup would be something which should be acceptable on both sides. So both sides meaning that essentially both the recipient entity as well as the paying entity. India, of course, did not agree to that position under the BEPS initiative. So that was not a common minimum standard. And essentially, if you look at it in terms of how it's progressed in the local jurisdiction of India itself, while during APAs and other, even the position which India has subsequently taken in the UN Transfer Pricing Manual, it was that they would want that the low value intergroup services, when it is a payout from India, it should actually have a cap, and that cap would be dependent on the revenues or the incomes of the particular AE in that particular year. So saying upfront that actually India has not accepted the position which was otherwise outlined in BEPS and has essentially stuck to that even in the UN Transfer Pricing Manual. So if I look at how they have now addressed this under the safe harbor rules, is that as long as it is a payout and it's essentially about a level of rupees 10 crore, there of course they have accepted the 5% mechanism. But the strange thing is that if India was to receive this as a payment for rendering services to somebody in the MNE group from India, then in that case there is no safe harbor for that. So essentially there is a dichotomy in that sense that one would have expected that the same, at least for receipts up to 10 crore, the same would have therefore applied on account of lower intra-group value-added services which are being received by India. So yes, this is, I would say, only a minor relief in terms of a safe harbor, because low intra-group services, an MNE has to take the same position on either side. It will therefore be difficult for a number of these cases to be resolved under the safe harbor provisions. So back to you, Karishma.
Sure. So, and I think in addition to that, even the services that are covered, are pretty restrictive. Simple things like IT support and sales and marketing, which generally form part of the management group services charges, are excluded. So, if you're making a payment for IT or marketing and support, then these are not covered, even if they're below 10 crores. And if also you have services where they are saying you have reliable comparables, now they could even be simple administrative services for which you may have comparables, then those are also excluded. So my question then is, what is included, But in any case, the most important point here is the guidance around documentation. And, I would like to get Mukesh's thoughts from a litigation or a tribunal standpoint. We've seen a lot of issues on management fees. And do you think this is going to have some positive value?
Just a couple of observations just to support and echo what Ashutosh and you have been talking about. Clearly, the safe harbor riders have made the overall implementation of safe harbor a complex exercise, and it's bound to open up even more litigation. Firstly, second thing that I observed is that under the 2013 guidelines on safe harbor, the R&D units did not have any limits. Those limits have now been imposed, which really means that large development centers in the R&D now need to meet the threshold. So in my view, the law is regressive on R&D centers, because in the past large R&D centers were also covered. So you have reduced the safe harbor limit for R&D centers, but you have imposed R&D centers which have a turnover of, I think, 200 crores or above are only covered. So that, in my view, is regressive, which opens up, which opens up avenues for litigation, at least for large R&D centers. To your point, what would be the persuasive value of these safe harbor limits insofar as a current set of disputes are concerned? I would say that certainly it will have limit, but I think it will depend also on the pragmatism of a particular member in the tribunal to be able to adopt the safe harbor limits. So there will be two aspects that will be driven by pragmatism of the tribunal members. Number one, if there is a taxpayer with a dispute who doesn't meet the threshold requirement, will the tribunal apply it purposively for those taxpayers? The second would be what happens if the tribunal is adjudicating on disputes currently because the safe harbor limits are on a prospective basis. So I think it will all depend on the mood of each bench of the tribunal, to what extent can it take a liberal and a purposive view of the 2017 safe harbor guidelines. To your other question on management fees, I think that we are entering an era of more complexity on management fees because the tribunals themselves have been inconsistent. So you have Delhi High Court talking very clearly that the role of a transfer pricing officer is restricted only to measure the arm's length standard of a management charge and not to get into the veracity or the commercial rationale of incurring those costs. On the other hand, you have many tribunals that are setting aside the cases for de novo assessment and verification of evidence whether these services have been rendered or not. So I think tribunals themselves have been inconsistent, and now you're going to add another layer of confusion because of these new safe harbor limits that have been come, at least in the context of payment for services that you're going to make. Ideally, what would have been reasonable is to say that if India is going to accept low value services margin, at least insofar as the receipt of services is concerned, then there would be limited verification. And I don't think that has happened. So I would echo what Ashutosh talked about earlier, that the safe harbor, that the low value services limits are there, but they apply only to a situation where you're receiving the services and not providing the services. And in my view, that's a very half-hearted approach from a tax policy standpoint.
No, I think thanks, Mukesh. What you're saying, I agree with you in terms of the inconsistency on the tribunal, and some of the most negative rulings that we have seen on management fees are coming from the Bangalore tribunal. And two such rulings, one being Gem Plus and the other being Volvo, in the decision have actually said that just giving documentation on a sample basis is not adequate, but you need to give invoice by invoice documentation.
Right, and last month also Herbalife.
Absolutely.
Yeah.
So I think the safe harbor, the only ray of hope that I was seeing that safe harbor is defining that, okay, if you give an accountant certificate which defines the allocation methodology and excludes shareholder and duplicated costs and gives reasonableness of the allocation key, then, and if that certificate is given at the time of audit, then can one say that, okay, if it has been accepted as adequate documentation in safe harbor, this should also be adequate documentation is given to the tribunal. Of course, it is interesting that who is an accountant, and they've also included foreign accountants, and they have classified various categories of having two partners, being a practitioner, having gross receipts of certain limit, etc. So they are also trying to, say that we don't want a certificate from any accountant, but an accountant of a reputable, and a credible stance in the profession. So, and just going back to the point, and then to conclude on this, linking to what Mr. Dixit was saying, that, India has said that when services are rendered from India, then cost plus 5% is not fine, right? Because that's excluded from safe harbor rules.
Correct.
But if you compare some of the other global safe harbor rules, if you look at some of the other developed, countries, and while India may call it developing, but I would say on transfer pricing it is as developed as some of the other developed countries. US has like a liberal safe harbor. UK has a safe harbor of cost plus 10. So yes, I would say that India may not have accepted a cost plus 5 that the BEST is recommending, and maybe could have had a higher threshold for rendering of services, say a cost plus 10 or 12. But I think it would have been good had India also considered a safe harbor on rendition of services which are low value adding in nature. So really, that takes us to our next and kind of the last theme of the webinar, which is on the interplay of safe harbor with other dispute mechanisms. And, before jumping into that, I would like Mr. Dixit to touch upon his practical experiences, of the APA program. He was part of the government. He's seen it from that side. He's been here. He's, advising clients this side. And Mr. Dixit, what is your take on how the APA program has shaped up till date?
So, overall, I would say that the APA program experience has been a very positive one. I think both from the side of taxpayers as well as from the side of tax administrators. And one of the main reasons for that is that, along with the program, an institutional structure or an administrative structure was created within the department where the APA program was isolated from the actions of the field authorities. And I think that is what essentially has helped in the success of this program, because then officers who had a background in this area, they were allowed to operate with a degree of autonomy and therefore a degree of give and take, and they were able to understand the nuances of different kinds of business models for taxpayers which are operating in India. And I personally feel is that the safe harbor rules themselves, the revisions which have currently happened, have been greatly informed by the inputs which were received by the department during the APA process itself. And therefore, in that sense, the APA process itself has led to this positive, spin-off where you have, despite what we discussed and, even given the downsides, I would say a much more positive safe harbor provisions, which I think will be able to satisfy and cover a number of taxpayers. The other thing which the safe harbor rules, the current ones, I think they help in the APA program, is that there is already quite a substantial backlog of cases, under the APA mechanism. And I think the tax administration has realized that if they want to have a quick turnaround in the APAs themselves, then they need to isolate the APA negotiations to specific transactions which are complex in nature, and by their very nature, therefore, they need to have a 1:1, kind of a negotiation for handling them. And they would therefore be expecting that a number of requests for an APA would either get withdrawn or would get covered by the safe harbor rules. And therefore, in that sense, the backlog before the APA program would, going forward, get reduced. So, essentially, that is how I look at it. Also, whether one should go in for a safe harbor or an APA. Would you, Karishma, want me to discuss that right now, or do you want to cover that later?
No, you can discuss it. Go ahead.
Right. So overall, I would say is that, of course, the nuances will be discussed by Karishma. The exact the pros and the cons, and the nitty-gritties of those details have to be done taxpayer by taxpayer basis. But essentially, if we look at it from a policy perspective, if this is the thrust of the tax department, then at least those particular transactions which are simple in nature and which otherwise would be getting covered by the safe harbor rules, I think that it would be advisable to try and take that coverage under safe harbor rules rather than expect that by negotiating those transactions under an APA mechanism, one will be able to get a lower threshold. So reverting back to what I said, a number of the percentages which have come into the safe harbor, I have a feeling come from the experience of the APA program. And if the government's intention seems to be that in order to reduce the burden on the APAs, then it would be, I think, slightly unrealistic to expect that by negotiating an APA on the kind of transactions which are currently being covered under the safe harbor rules, one would be able to get anything which is substantially less or significantly less than what is being offered under the safe harbor. So that's the overall, comment on that, Karishma, and I'll hand it over back to you.
Sure. I think, that comment is very important for the audience to understand that safe harbor revisions of markups have been, instigated, you can say, by the APA, backlog of applicants. And I think the government intention is, to get the people out from the APA program and move to safe harbor if they're below a particular threshold. And I don't think one should really expect that the markups are going to be very different. Having said that, there are pros and cons, as you briefly explained, and, just to touch upon a few of the important ones, and again, to assess whether, an APA or a safe harbor is the right program or dispute platform or some other platform, it's a very fact-specific thing, and, you really need to have brainstorming in terms of the right approach to be taken. But overall, if you see the APA program, definitely it lands more certainty because one, you're getting it for a longer period, which is a 5 + 4 years. 2, you can have a rollback. 3, it can be bilateral, which means you can avoid double taxation. And 4, the most important, it's optional, which means, if a pragmatic approach is not followed, you have the option to walk out of it. Now, when you compare this with the safe harbor, really safe harbor is only for a 3-year period. And having said that, you need to apply each year. So it's not that you made an application once, then you have a safe harbor for 3 years. Each year, the tax officer will look at the application and assess whether you fall in the eligible transaction or assessee list and accordingly give a ruling. Another most disadvantageous position for safe harbor is it's unilateral and therefore there is possibility of double taxation. And another aspect which is important, which the government just about a day back, the CBDT came out with a release on the change in the application of the APA, which is, amending the 3CD form to cover details of the ultimate parent holding. Now, if you read into that, then really I think the APA program is going to gather a lot more data going forward for the larger companies through the exchange of information route. Because all that is going to do is ask for this information from the ultimate parent country jurisdiction and then try and assess that from a risk assessment perspective as to how it would impact the APA. So I think a lot of these aspects, will have to be weighed in mind when you decide, whether it's benefiting you or no. The most important thing one needs to also consider is the timeline, because if you really see the timelines of the APA program, they have been on an average for a unilateral 2 to 3 years and for a bilateral 3 to 4 years. And there is an application fee, which is also a high application fee. Now, these aspects are not there in a safe harbor. It's much faster. It happens within 6 months. There is no filing fee. There is no mandatory site visit. But in an APA, you have a mandatory site visit. So a lot of these aspects need to be considered, before one can really consider as to what is really the right option. And Mukesh again comes with a lot of experience on having handled maps and bilateral APAs and pursuing litigation. So Mukesh, what is your thought in terms of how should one approach this, choice?
Well, I don't think that there is one size fits all situation over here. You have choice of map where because now India is a signatory to MLI in anticipation that the map process will improve and there would be a defined time period of 3 years. Well, the MLI merely says that the competent authorities shall endeavor to settle the dispute in 3 years' time. But I think the peer review process will put pressure on India. So I see the map process in terms of timing improving as we go forward. The other important element of MLI is that the relevance of Article 9.2, which was prohibiting a map resolution for countries that did not have the Article 9.2, in particular in particular France, Germany, will become less relevant. So now you will have treaty partners in India by way of France, Germany, and we already saw Singapore getting covered as a result of amendment to the treaty in December last year, will get covered. So that's really the efficiency part of the map that comes in. As far as the APA is concerned, I agree with Ashutosh, the point that he made earlier, that the APA program will get accelerated as a result of the new safe harbor limits. So there are many applicants in the APA program that will meet the threshold of small or medium enterprises. And that would be good because in that case, the APA commissionerate will be able to focus on complex transactions and large taxpayers. And I think that this is certainly going to reduce the inventory of MAP. I think as far the safe harbor limits is concerned, I'm a little bit skeptical. As I mentioned earlier, I think it is too complex, it is unwieldy, it could give rise to disputes on eligibility for safe harbor, besides the fact that I'm disappointed that there is now a threshold for the R&D centers, which was not there under the 2013 regulation. I think they should have retained that. But I think all of this will now, there is one more variable, Karishma, that I wanted you to talk about, which is the secondary adjustment. And any decision as to what form of strategy the taxpayer adopts, whether MAP, unilateral or a bilateral APA or a safe harbor, is now dependent on the secondary adjustment as well. Of course, I have not discussed the fourth option, which is pursuing normal litigation. But I think over a period of time, if the MAP process improves, you will see a reduction in the litigation at the tribunal level as well.
Sure. I think I agree with you that timing is going to improve. You're going to have better platforms for dispute resolution. Of course, Germany, they had not included us in the list, and I don't want to, as our competent or our principal commissioner has also said, held out in public.
Don't read too much.
Read too much into it. We may see that coming soon. But secondary adjustment, as you rightly said, is really crucial because, and we've been having this discussion, Mukesh and Mr. Dixit, since the time this press release has come on secondary adjustment. If you see what the press release basically mentions is that the application of secondary adjustment will take place if the primary adjustment is made in respect of assessment year 17-18 or subsequent years. And this is very important, the word made in respect of, because this would rule out any bit of retrospectivity, right, which we were contemplating. So that's the first important amendment. And the second important, clarification that they're putting out is that the time limit for repatriation of excess money is 90 days. From the prescribed date, failing which notional interest on money not repatriated will be charged. Now, another interesting angle to this is they further go to clarify to say that if an assessee has appealed and there is an appellate order, then the 90 days time period will trigger from the finality of the order. And here, Mukesh, we've had this discussion as to would this really also be covered? Because if you see section 92CE, there are 5 conditions under which secondary adjustment gets triggered, and 4 are very simple to read, right? Which are all voluntary. 1 is suo moto, 2 is MAP, 3 is APA, 4 is safe harbor. Now all these are voluntary. There is a 5th condition which says where an assessing officer has made an adjustment and assessee has accepted, which also would mean that assessee is accepting the AO order and not going into further litigation. So if you decide to pursue the non, which you were mentioning in the earlier slide, then technically there can be one view to say that secondary adjustment does not get triggered, because if you go by the strict reading of the law, it is imposing a secondary adjustment only in voluntary situations and not in a situation where you have appealed and say you lose the appeal at the ITAT or at the High Court or at the Supreme Court, and then you're forced to accept that outcome.
Correct.
So Mukesh, just you can have the last word on this. But
no, so I am in agreement for a change with you that the section 92CE envisages all the 5 situations which are voluntary, and the word used is accepted by the SSC, and acceptance cannot be imposed or thrust upon a taxpayer. This is further supported by 2 aspects. The OECD, which prescribes for secondary adjustment, has given both the options. Secondary adjustments in a situation where the taxpayer accepts it voluntarily, and secondary adjustment where it is imposed. For example, if you look at the draft UK secondary adjustments paper, which UK did not implement, the UK FAQ envisaged both situations, where the taxpayer accepts the primary adjustment and repatriates the money, and in a second situation where the HMRC imposes that. India has followed a liberal approach insofar as section 92C is concerned. This was also our view at the time of the webinar on the budget. I agree with you that there is some element of incongruity that has got created because of the recent draft circular by the CBDT, which envisages a situation that it is only on final determination. But I think the statute will override the CBDT notification. The CBDT notification also is in a draft form, so one can expect that the CBDT notification finally will clarify. This could not have been the intent of the lawmakers, and if this is the intent, they will have to amend the law to say that if a taxpayer chooses to appeal, then eventually whatever is the determination with the appellate authorities, that will guide secondary adjustment. The other reason why I feel this is voluntary is, we will continue to see a situation where high-pitched transfer pricing assessments will happen for some reason or the other. That does not in any manner mean that those high-pitched assessments should result in multinationals remitting what they call it as excess money under the secondary adjustment into India, because that will make the foreign investors extremely nervous. So I am in agreement with the interpretation that it is voluntary. If a taxpayer decides to appeal against a primary adjustment, then section 92CE fails, and taxpayers will not be expected to carry out a secondary adjustment, in other words, remit the excess money into India. So that essentially is what we wanted to cover. Let's move on to the Q&A session. I have a couple of questions which I'm going to direct first to Ashutosh and then to Karishma. Ashutosh, the question is whether safe harbor margins will impact margins being negotiated at a bilateral MAP or an APA process.
So I had covered this briefly when I spoke, about the safe harbor and their interaction with, and this question is about the MAP process, MAP and APA, right?
Correct.
So essentially, if you look at step back and look at it that from this point of view that the intention is to reduce the current backlogs in the APA process, then this would be a signal that the APA authorities are not going to be very flexible on negotiating anything which is lower than what is being offered in those simple transactions which are covered under the safe harbor rules. In fact, they may turn around and say that you are asking for certainty for over a 9-year period if we take on the rollback period also, and therefore that would be an additional reason for them to say, besides the policy perspective itself, that they would want that the simpler transactions go and get covered under the safe harbor rules. Under MAP, I think this is a positive indication for current cases which are under MAP, because I think it does give an anchor to the competent authorities under the MAP provisions, or a signaling effect to them on what would be something which is acceptable, to both the taxpayer as well as the tax administration.
Thanks, Ashutosh. Karishma, I have a question for you. The provisions of secondary adjustments are applicable from assessment year 18-19, and the section also provides that nothing will apply if the primary adjustment doesn't exceed 1 crore, and the primary adjustment is for the assessment year commencing on or before April 2016. The explanatory memorandum provides that the provisions shall be applicable to primary adjustments exceeding 1 crore rupees made in respect of assessment 17-18 onwards. Considering the above, whether the Act will prevail over the rules, and accordingly whether the provisions of 92 CE will not be applicable for assessment year 17-18.
Yeah, I think, the provision of 92 CE is applicable with effect from a particular AY, but that would not preclude to within the particular section, the government saying that this provision will apply in respect of particular assessment years.
Okay.
So I would want to say that AY 17-18 will get covered because, the intent is that, because this section will start with effect from 1st April 2018 assessment year, which would mean financial year 1st April 2017. But if say you're filing a return in November, right, and you make a suo motu adjustment, which is pertaining to AY 17-18, right, which is financial year 16-17, it will still get covered because the section 92 CE is clearly saying in the provisions for which assessment years it will be applicable to, which is also what we read in that circular, which clarified that it is for assessment years in respect of assessment year 17-18.
Correct.
So that is, I think, would be a better way to interpret. But of course, this may again lead to litigation or some interpretation issues. But yeah. And I think maybe we can take one last question on, how do you see the safe harbor rules apply for inbound financial transactions? That is, foreign parent debt funding a wholly owned Indian subsidiary, or in case of a guarantee provided by the foreign parent, how will the non-deductible element of the interest expense at the level of the Indian company be viewed by the authorities? Now, over here, if you see, safe harbor rules are applicable for loans advanced, and it is not applicable, in cases of inbound transactions. So I really don't see that to apply, because really I think you will have to go by the normal benchmarking approach, because that is not covered.
We have 2 more minutes, so we can take one more question. Are the revised safe harbor limited applicable on the IT-80 rulings for the previous years, which is pronounced during financial year 16-17?
See, that goes to the point of whether the safe harbor rules will have persuasive value, right, to the IT-80. Now, my view on this is, we have had this issue of whether foreign expenditure, forex loss or gain is operating or not. if you see the safe harbor rules, it defines forex loss and gain as non-operating. And it was after that provision in safe harbor rules that we saw a couple of ITATs, relying on that to classify that as non-operating. So yes, I would tend to agree to say that certain definitions given in the safe harbor rules, etc., can be used from a persuasive value when either the taxpayer or the tax authority is making an argument. But on the markup, I would tend to disagree because, markup of a safe harbor is not arm's length. It's a markup to buy peace of mind. Now, what the markup would be really determined on the basis of comparables in the given case. And I don't think that the ITAT may get swayed by the markup.
Thank you. Ashutosh, before we end, you may want to have a last word on anything that you want to clarify.
Well, I think we've covered, most of what we, on the three topics which we talked about. Just one more thing, on that particular question, on basically payouts on interest from AEs. Just to add that, this budget has thrown in the thin capitalization rules. So I think we need to be much more concerned on that particular front regarding the disallowance of the expense itself, and then come to what should be the margins on that particular interest.
Okay. Thank you. Well, this brings us to the end of the webinar. I'd like to take this opportunity to thank all the participants and my colleagues, Ashutosh and Karishma. Please do write to us. You can still post the questions on the link that has been given to you, or you can send the questions to corporatecommunication@bmradvisors.com. The presentations will be uploaded along with the reading material, and the reason we felt that the reading material was important is because there have been several jargons that have been used, and it may be difficult to follow all of that. We did not want to capture all of that on the presentation, and hence the annexures will have a complete deck. We will also put out the presentation only and not the Q&A in the firm's social media sites on the LinkedIn and on the Twitter handle as well. Thank you very much for your participation. Have a nice day.